law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you because the law matters. Understand the law better, and you're in a better position to protect yourself, your family, and your business. We've been providing resources and information that may help you determine whether or not you actually need to have a lawyer. In some cases, you may be able to do it yourself. In either case, with a little extra information, hopefully by the time you decide that you might need an outside counsel, an outside lawyer, you'll be better prepared, and as a direct result, so will they. In either case, you'll save time, money, and hopefully achieve better results. We want to thank the Bazar Grasso law firm in East Providence that continues to help us by offering their insights and experience on all of the topics that we handle, and we want to welcome David Bazar today.
Hi, Debbie. So
today, your personal privacy versus national security. Seems that written everywhere in the news are opinion pieces that since the recent Paris terror attack has begun, there's been more information about the American debate and whether or not we should be more concerned about privacy versus security. The intelligence leaders, former and current, seem to allege that the recent leaks and limits on surveillance actually played into the terrorists' hands. Did they? I don't know. And what, if anything, should we do, even if that were the case? So prior to Paris and the Charlie Hebdo, we had Snowden, who engineered his own version of how to oppose the data spying and the invasion of privacy, and exposed the threats at home. So of all of the human rights and international catalog that's available, privacy is probably one of the more difficult ones to define and circumscribe. So we thought we might ask David to handle that today. So starting right off the bat, I care about my privacy. I also care about national security. How do we approach, and should we approach, one versus the other? How do they coexist? What do we do?
Well, you care about both, and that is the whole issue. It's balancing. You have to balance the national security against a person's individual right to privacy. And that's been a constant issue whenever there's a crisis or a situation that the country faces, going back to the beginning. And in particular, I can think of examples such as during the Civil War, the writ of habeas corpus was suspended, which is, habeas corpus is a writ that says a court ordering the state, the government, to bring an individual before the court so their rights can be adjudicated, so that you can't just hold a prisoner or person without that person ever getting his day in court. So during the Civil War, that writ was suspended, and so people could be held for unlimited periods of time without any charges being heard or presented to a court. So, you know, these are things that the country has faced every time we get into a situation where there's a security issue.
So when people talk about privacy and that being an individual right, I don't know if it's a foregone conclusion anymore, but I guess people can't avoid talking about technology. It's a wonderful and helpful thing, and in this context that we're talking about with the recent spate of terrorism attacks or threats, it's your privacy, your digital privacy is not the only thing in question, but it's being in question in the workplace, in your home, in the local coffee shop. Information privacy, territory privacy, your bodily cavities being searched, privacy of communications. Where is the boundary? How much are we supposed to sacrifice constitutionally? How do you evaluate that?
So the evaluation is basically the government's need to protect us versus your right to your privacy, and there's a shifting boundary that comes along all the time. And it shifts a little bit towards the government's need to get information for security interest when things like Charlie Hebdo, the Paris attacks, those things happen, and back towards, well, we still need to protect the individual's right to privacy. And so it's the little fine shift in that really becomes the issue. For example, right now, or in general, the government needs to get court orders to do wiretaps. And when I say wiretaps, it's almost like, what is that? That's old-fashioned, because I remember a case in Rhode Island where the government, the state, was arguing they didn't have to get a wiretap to intercept wireless phone calls, which were just being made in the open with the unsecured conversations easily picked up on a radio transmitter receiver, where there was a drug deal that was being talked about, and there was no wiretap for that, and they got all the information. And the court said, well, there's a lower expectation of privacy in phone conversations that are broadcast wirelessly, and therefore they didn't need a wiretap. So technology changes where you can go and what you can expect. But in general, it's where is there a reasonable expectation of privacy? And so if you have secured conversations or digital, as you say, footprints being left through the internet that are supposed to be secured, then where does the government have to get a court order to be able to get that versus when can they just take it? And that's where this line shifts. So generally speaking, if there is no imminent threat to the national security, then you would expect the government to have to go to court and get a court order to get something. Where there is an imminent threat, you might relax that requirement a little bit. And where that happens is the gray area that we're constantly looking at.
Certainly sounds it. I mean, just as you're saying that, law enforcement will, on a given, almost at a drop of a hat, think there could be an imminent threat. Well, there might be, or there might not be. It might be an imminent threat that is, I don't know, not certainly on the scale of a national threat, but certainly I understand why there are many opposition groups, not just the ACLU, that adamantly oppose even the slightest sacrifice in an individual's right to complete privacy, saying there's just no containing the government or the law enforcement or whatever, because almost at a drop of a hat they can have access. I don't know if that actually means when the government says they just want to have a vacuuming or a sweeping of the metadata versus David called and talked to his mother and said thus and such. That's a very different kind of thing. But do we have to make that kind of distinction? Sweeping metadata that tells really nothing versus wiretapping, as you're saying. Is there a big difference that we have to be careful of here?
Well, I think there is, and from the ACLU's perspective, as you say, it's a real slippery slope, because if you say, well, if there's an imminent threat and the government can go and get everyone's data or whatever, or someone individual without court authority or court supervision, then how do we know when that should end? And it really also should be looked at as this, I think, and that is that we have freedom and liberty and privacy and all of those constitutional guarantees in our Constitution that are what make the United States and freedom a very important thing. So when you start infringing on that, at some point, if you go too far, it's in reaction to terrorist threats and everything, it's almost like you're saying, well, they won. And that's not where you want to go with it. You don't want to start limiting your freedom and your right to your liberty interests in response to that in a blanket manner. You want to have a very scaled response to it. And so, as you said, metadata, getting it in bulk and finding like things that ping out to the security experts that now we can go look at, and perhaps if they need to then go to court and say we need a particular wiretap or right to look into the data of this particular person or that, that's all fine. But I think the government, if they're able to, just by looking at bulk data without looking at your particular account in general, and are able to find the things that would give them the red flag, so to speak. That's the balance that you have to take.
So certainly, within the past few months, it's not just an American issue. We have ISIS, we have terrorism. Now we have Paris in play, we have Germany, we have Britain, and each one has its own set of what the rights to privacy are, and they're not necessarily ours. Some better, worse? I think even Switzerland is probably the most lax. I think it takes an act of, never mind an act of Congress, an act of God to get some information out of them. But is that, should the conversation about Paris and Germany and what Britain is doing, should that be playing into what we are willing to change on our home front? Because now Paris might care a little bit more, where they didn't perhaps before. Now they're threatened and they're concerned, so should that be impacting on our decision about how much we will share?
Well, yes and no. And the no part is our Constitution, as you say, our rights may be different from the rights that the people in France have or in Germany or in England. Yes. So every country has to impose its own answer based on its own rules and constitutions and whatever the rights of the people are in each of these different countries. So the way the rules are imposed might be different. The reaction to what happened in Paris and the reaction to what happens in other countries is important only in the sense that the government and the people who are charged with protecting the security of the United States have to acknowledge that these threats exist, and that if it's a threat to France, there could be the same threat to the United States, and therefore act accordingly. But the way they impose whatever surveillance or invasion of privacy of an individual's rights still has to be regulated by the laws of the United States.
So if it comes down to it, where the government just decrees, there is an imminent threat, and so all bets are off, we can invade. We can have complete access, unfettered access to everything. Is that legitimate?
No. And they can't just say, imminent threat, we want everything, without following the rules. And there are rules in place as to what they can and cannot do. What I'm suggesting is that the courts might relax how much information they can go get and how they might do it, or Congress might try to pass a law to give more rights to the government in looking into our privacy. But the court is the final arbiter of what they can and cannot do, because if the law that's passed by Congress, if it's signed by the President, and becomes a law of the United States, still is subject to the Constitution. And so it can still be challenged. But I think what a court might do in response to the given situation is different. If you're in a peaceful situation, there are no threats, the court's not going to really allow the government to shift into being able to look at everything that everybody does, or even a little bit of what everybody does, as opposed to when there is a need to get information for security reasons.
Well, you know that the color of that alert is getting brighter and brighter as it is right now. So does that mean, do you have a sense that the court is more likely to be considering the collective good, the collective value, versus an individual's personal right to privacy and solitude and everything else that's digital?
I think history has shown us that that is how these things cycle in times of crisis or conflict. So that's probable, but it's also possible that a court might create a rule or an order that's limited, and maybe limited in time or scope or otherwise, given the current situation that the country's facing.
So, of course, the ACLU has been writing paper and thesis after thesis and causing an uproar about what's considered to be the watch list. It doesn't take much to be on a watch list these days, and that's not just about vacuuming, sweeping metadata. They're concerned, and in many cases, rightly so, you might have had the wrong color skin or shirt, and that enables you to be on a watch list that is now impacted and had serious consequences on what you do and how you do it in this country. Are we supposed to be very concerned, too, about the ACLU and making sure that they don't let too many of our rights, our right of privacy, slip away?
Well, again, and I think that's the slippery slope that they're worried about, and that they don't want to see us go down, because once you move the line somewhere and say, okay, well, you can do this based on whatever profiling or information or whatever types of things that give you the concern to start looking at this person's data. Well, why can't the line just keep moving until it's everybody's data? And that's that's part of the slippery slope that you have to be careful of. But again, you're balancing that against the need to have information that you can then, as a government, react to and use for security purposes.
How do you evaluate, or should you evaluate, the difference, thinking about digital specifically now? Usually, digital sacrifice of your privacy is tied to some consumer protection. Well, in this case now, as we're talking about all things terrorist, it's not my consumer protection and whether or not my identity and my credit has been hacked, but rather another larger issue. Should there be that distinction when it comes to what kind of privacy we have in the digital world? Just consumer protection? Is that enough? Is that worthy of sacrificing my privacy so that they can take care of that?
Well, the answer to that is complicated because
Yes.
this whole data world is complicated. So what is it that they're getting for information? Credit information, purchases, that kind of stuff? I don't know that that's as important to them as who you're talking to, what are you saying, Facebook, Twitter, all these other social outlets. And actually, as I understand it, there's even more information being passed between people that they should be watching in different forums. PlayStation. Yeah, PlayStation and things of that nature. And how can they follow that? Can they get information from that? Is that fair game? Should that be protected? All of these things, they evolve as technology evolves, as the web evolves, as people's use of it evolves. So I think the government needs to stay on top of what they need to stay on top of. And in terms of consumer protection, there may be a need for them, and maybe they need to go to court to get it, to follow after you've been flagged because of something that's come up and it creates issues. Well, if you're buying things through the internet that might be of concern, bomb-making materials or whatever, shouldn't they then be able to follow those purchases too? But
yes.
Now you run to the other side
Yes.
is how does the government protect the information they get? Because suppose it's you, and we know you're not a terrorist, and there's no information that you're going to have from being hacked by somebody else. So they should be able to get the material they need to get, and sometimes through court orders, sometimes maybe in bulk, as you say, but they also have to make sure they're protecting the data.
And in one interesting recent example about the financial situation, so digitally it means that if you're doing banking online or you're doing much that's online, the government can say, well, we want to protect your credit, your identity, and we don't want there to be theft, and we want to protect your financial situation. So that sounds very good, and yet the other side of it is they could also not just be watching for my personal financial protection, but perhaps I'm doing some financial trading that's illegal, international, and enables some terrorists to buy guns or by terrorists or by soldiers or whatever. So watching the digital financial trail is not just about consumer protection at times, although that's where it started out or might start out, and it ends up being something that the government can say, yes, it's really a matter of our national and international security.
Yeah, and that's what I was saying. But it would seem to me, depending on the situation, that once they've developed a profile and information that gives them the concern about an individual, in order to follow up on that, to go to the court to get the order to say you now have the right to go and get all the other information that would give you a better track of what that person is doing, is probably the way to do it so that the person who's not doing anything wrong, rights are protected, so that the government can't just go out and get every piece of information on you through the internet or the banks or all of those types of things, but rather has a process that has some protections in it. Give the court your suspicions, your reasonable right to go and get that information.
So if the courts are responsible and sensitive and trying to protect my privacy as an individual, and yet we have global threats something else happens in France or in Turkey or someplace else. And now, since we have been moving towards a shared, never mind economy, a shared database, isn't it likely that once that information has been shared across the pond, somehow my thought of privacy, even though the U.S. is protecting it, I'm not saying that France isn't, but then suddenly that's not even within the realm of possibility because it's become viral. It's global and out of control, literally.
And that is on the other side of the concern. Where are you protected, and how far can the information that's gathered about you be shared and shared with other countries, other security agencies for other countries? And so you would assume that there's a great deal of protection on the information that's being shared and all of that, but we've seen these hacks and things come up before, so you never know.
So while we've mostly been talking about communications being tapped or watch lists and digital technology, what it can do, there's also the other issues that I sort of alluded to at the top of the program, biometrics and DNA. That's certainly more than an invasion of privacy. It could be a matter of national security, but how far do we go? Are we supposed to be suddenly adjusting our sense of the right to privacy in those camps too?
Well, for example, and this goes back a little bit to just general crime fighting and police procedures. So back in the day, when you got arrested for something, what would they do? They would take your mugshot, so they have a photo of you, note characteristics, scar or tattoo or something,
birthmark, whatever,
birthmark, and take your fingerprints. So now, should they be able to take your DNA? Because now DNA is an even more useful tool potentially than fingerprints, and so that is the evolution of science and technology in the crime-fighting world. And it's hard to argue that if they can take your fingerprints at a certain stage in a criminal procedure, why wouldn't they be able to take some DNA too? So that's part of where this whole thing is going. Biometrics, tell me what you mean by that.
Oh, they might be looking at iris scans, or they might be looking at DNA. But all of those kinds of things are inputs to an overall picture that's other than your mugshot. I think that at some point when they start talking about how far-reaching this can go, I understand the sliding scale, I understand some adjustments that might be necessary, but some of these become perhaps a little bit too expansive. When we talk about how wonderful technology is, and now we're having 2 layers of encryption, that's good for security, and I have no trouble about that. If they're going to put my thumbprint on my phone and I have additional security, I have no trouble with that. By the time somebody else is saying, I want to swab your cheek because I think we have a routine stop, but we might not know whether or not you're a terrorist unless we check that out. How far do we go when we, at every stage of the game here, especially from a traffic stop to we think you could be a terrorist? There's got to be some sort of protocols for each, and maybe it's not just one blanket, we have all rights to all privacy or no rights to any privacy.
Right, so that's, if that's where you're going with that, that's what I was saying, is you can fall back to our criminal procedure and our constitutional protections and all of those things, so that you're stopped for a routine traffic stop and they want to take your DNA, they can't. There's a procedure as to when they have to have probable cause and the right to ask you to submit to that type of thing based on a particular case or a particular set of facts that bring you to the attention of law enforcement for a particular either crime that they're investigating or reason that they think they're entitled to get that information, which might require them to go to court to get a court order for you to submit the sample.
You still might lose that battle, but it might not be an automatic loss. It might take some time before they get to do it. So when people are having this debate against and for saving my privacy, it's one thing to say you're for it, we worry about Big Brother, but then there's the argument, and I guess we've had this discussion with constitutional issues. Well, if you have nothing to hide, why would you care? Is that really what the question should ever be, David?
No, it's not the real question. The real question is, when should government have the right to invade your privacy? When should the government have the right to step beyond what they're entitled to get without going to court? And so it's that balance that's the important question, not the first question that you asked.
And if the government has been finding new ways to develop increasing levels of security, whether it's a double authentication of something or greater encryption, perhaps this is a bit rhetorical, but that's for my privacy, but it's also not just about my privacy, because in fact someone could easily break that. Is there, in this pursuit, a reason to make encryption that can't be hacked by the company that creates the encryption? Is that a possibility?
So that's a sort of a different question to me, because I think you're just asking about protection of your own rights, not protecting it from the government looking at it.
Both, yes.
All right. So in terms of technology being created that makes it harder and harder for other people to get your information, I think that's absolutely fine and the way it should be. Will it stop the government from being able to get it, and would the government have a concern about that? Well, the government should, I'm not saying have a back door into those things, but what they should have is an ability through either court order or other process to be able to get whatever information they think they're entitled to get.
Should they be able to do that directly because they have people who are bright enough to unencrypt?
To break through,
to crack the code. Should they be able to do that directly, or should they have to actually go through maybe the firm that sells the software that made your data harder to hack? Should there be enough channels rather than them being able to go directly because they think they have a case?
I think it goes back to the same issue that we raised at the beginning of the show. Where does the government's right to get information in order to protect national security cross the line with your right to privacy?
What's reasonable? Yes.
And that's the reasonable question. And so the answer to your question is the same thing that we talked about right from the beginning, is where is the line and where do we cross the line?
And in thinking, there should be these levels in place, as I'm trying to interject a few safeguards or stopgaps along the way. It seems that that's appropriate, reasonable, helpful, and maybe not always efficient. Suppose it's so effective that it makes it there, it thwarts the government's interest and their ability to get to the information that they need that keeps me safe in the first place. And that's a great debate too. How many levels do you put in place that makes this ineffective anyway? So why would you even bother trying to take my privacy away from me? There's nothing you can do that makes me safer anyway.
It's a big question.
It's a big, convoluted question.
And it's, again, it really talks to when technology is created to help the consumer, the individual, and we're really looking at this technology as being created not to hide our information from the government, but to protect it from being hacked by people who want to use it for their own gain. Yes, that makes sense that you should be allowed to create and have that technology. And then the question becomes, is it now going to be used by people who are using it for nefarious purposes, for setting up information being exchanged to attack people or countries or whatever? And how can the government then go through it and defeat that technology in order for them to get the information that they need? And it goes back to when they're entitled to just get the information or when they need to go to court, and what can the company who created that technology use to say, wait, we don't have to give it to you. And I don't think that they would be able to defeat that if it was through a court order.
It's quite a debate, quite a long question. The discussion, the debate continues, the law matters. Stay tuned because it matters to you.